Hey, what's up everybody? This is Isaac from Guns for Everyone with the second video of the day. Fuck the algorithm. Alright, here we go. First and foremost, let's bless this video with a little bit of prayer to Santo Edgar. Santo Edgar, make this a good video. Alright, we blessed it. I want to talk about something. I've got a lot of ideas in my brain at the moment about videos that I feel like I need to do. But this is one that I have sort of kind of promised that I would do to some people recently, so I kind of went to the top of the list. And that is the topic today in this video is why we should not be seeking self-defense advice from attorneys. Attorneys are really well experienced in the world of the legal aftermath of self-defense, and so it would seem like a really good idea to take their advice and to listen to them and make decisions based on their expertise and their experience. However, that's not how self-defense law works. It's not how self-defense works, and it's something that we should be very careful of. I would defer to an attorney when we're talking about legal aftermath. I would not defer to an attorney when it comes to making self-defense decisions, with one very important exception, which we will get into. And the reason this video is coming about is because as YouTube has gotten more sophisticated, I've been on YouTube doing gun tubing for like 15 years now, and I've interacted with a lot of people in the gun YouTube space. I've done videos for a long time. Not super successful videos, but that's not really the point. I've been in the space, and it has gotten so much more sophisticated in the last few years, and I think that's overall a good thing. But one of the downsides is you get people who are very polished in their presentation who are putting out bad information. So it seems even more authoritative because of good lighting or good miking or good advertising or blah, 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 blah. So the successful YouTubers, and maybe we'll just call them influencers for the moment, tend to pull down a lot of credibility when sometimes, maybe oftentimes, it's not earned. And attorneys come into this with a professional background. So they're not just like some dude who learned how to turn on a camera and be successful at it. They're actually coming from a background of being successful in a high-stakes profession like criminal defense law. One of my favorite YouTubers to watch in this space is Andrew Branca, and anything that I talk about today that came from his book, which is The Law of Self-Defense, The Law of Self-Defense by Andrew Branca. I want to make sure that I give him credit for that because he's done a masterful job at distilling down self-defense law into very easy to understand terms and very accurate terms, with one exception. All right, so this conversation, I guess, should start with the concept of what is legally justified self-defense and what is legally justifiable self-defense, because those two are not the same thing. It's really important when we're talking about this that we be as precise as we can be with our language. So let's start with justifiable self-defense. Justifiable self-defense is when you're allowed to make the argument that this is self-defense. Allowed to argue self-defense. What does that mean? Well, like, let's say you commit a mass shooting. Let's say you walk into a movie theater and you just start blasting. That's a terrible thing to say, but it's true. It did happen. Can you make the self-defense argument? Well, I don't think any judge in any jurisdiction is going to allow that argument. That's just murder, okay? But let's say you are a little old lady asleep in your bed and somebody kicks in your door and comes in and they've got a machete and they're going to try to hit you and you shoot them with it. Nobody would suspect anything other than self-defense in that case. Well, those are two extremes, and at some point between those two extremes, there is a line where we allow it, We allow the argument and we don't. And that line moves around. It's not the same across all jurisdictions and in every state. It's generally true across all jurisdictions, but different unique things can cause you to not be allowed to argue self-defense. It's incredibly complex. I'm not an expert in it, and that's about as detailed as I can get. Okay, so justifiable means you're allowed to make the argument. So that's a yes, no. Are you allowed to make it? Are you not? Usually that's determined by a judge. The other part of justifiable self-defense is the strength of your argument. Argument. Okay. The strength of your argument. How justifiable is it? In Colorado, there's a very famous case of a guy who walked into a bar back in 1993, and he was armed to the teeth. His name was Eugene Bayless, and he just started shooting up the bar. It's a little bit more complicated than that, but that's essentially what happened. And he argued self-defense, and the court allowed it somehow, and he actually got a not guilty verdict. He killed 2 people, put 2 other people in critical condition, and when you go and read the case, it's almost unbelievable that not only was he allowed to argue self-defense in that case, but that he actually got a jury to agree with him. So with very weak arguments, he still was able to win his case. And then you have other cases where people, sometimes it's hard to come up with examples off the top of my head, but there are cases where the typical layperson would agree that was totally self-defense, but somehow they still lose their case, and you have somebody with a strong argument who still loses. So strength of argument is not whether or not you're going to win. Strength of argument just gives you more likely, less likely to win the argument. Okay, if you got kids, you've been married for a long time, you got all different examples of weak arguments winning the point and strong arguments losing the point. But generally speaking, strong arguments win, weak arguments lose. Okay, so that's justifiable self-defense. Are you allowed to argue it, and how strong is your argument? Okay. Justified self-defense is pretty simple. No conviction. I mentioned this in the last video I did on this topic when I was talking about USCCA, and a justified act of self-defense is one that does not end in a conviction. A plea agreement is a conviction. A jury trial with a guilty verdict is a conviction. And if you get no conviction, then it's justified. I don't care about the morality. I don't care about the strength of the argument. I don't care about any of it. Did it end in a conviction or not? Was it justified or not? Okay, so that's our starting point. Well, when does all that happen? That happens after. It never happens before. There's not a single self-defense case in the history of law, at least that I'm aware of, I should be careful with such broad statements, where the act was justified before it happened. It always happens after it happened. So, what lawyers will generally do is explain to you how the law looks at different types of evidence, different witness statements, procedural stuff, arguments, and what they're trying to convey to you is weak arguments are bad, strong arguments are good. And that's a good point to make as an attorney, because they theoretically could be the one fighting your case. And it's important that you understand your likelihood of winning or losing your case. The problem with this is that we don't get to set up the self-defense encounter. Okay? We don't get to pick the time and the place and the conditions of that encounter. You as a defender are a unique person within this process. Your attacker is a unique person within this process. The context of what happened is a unique context for this process. And there is no way in any universe for us to tell you ahead of time what is going to be justified and what is not, because we don't know what the legal conclusion is going to be. Sometimes we could say, okay, give the little old lady example and say she's in her house, she's in her bed, and she gets attacked by somebody. We'd say we have a pretty good idea of how a case like that would go, but we don't really know. There was a case in Denver where a little old lady shot and killed an intruder inside of her house, And because of some statements that she made, and this was a long time ago, it was more than 20 years ago, because of some statements she made to the police, it opened the door in the investigation to question some of her arguments, and she ended up getting convicted and sent to prison. And so we have to be really careful about the conclusions we draw when we say, let's break down a self-defense case. The Kyle Rittenhouse case is a good example because it was so public. And we break down the elements of self-defense, we break down the arguments of self-defense, but we can't really say if it's justified or not until the jury comes back with a verdict. If we had taken Kyle's case as a hypothetical before it would have happened, you would have had plenty of people telling you it was totally justified and plenty of people telling you it wasn't, and none of those opinions matter at all. The only opinions that matter are those 12 people in the jury box who end up having to make the decision. There are as close to an infinite number of circumstances that can affect what happens in your self-defense encounter. And almost equally as true, there are almost an infinite number of circumstances that can happen in the legal aftermath. So lawyers giving advice on how to make self-defense decisions based on what they see in the aftermath is not useful information. The only useful piece of information that we should be taking from all of these attorneys' experiences, their conversations online, their YouTube videos, their cases that get published, etc., is a single word: risk. Do we understand the risk? If you understand the risk, then you can make better decisions. If you understood the risk of a self-defense encounter, you would probably be a little bit more careful not to get yourself involved in one. But if it's not up to you and you have to make those life and death decisions, that's forced on you. And you have to decide how you're going to defend in that moment. And what's the risk that's most important in that moment is the risk to your life or the life of somebody you care about. And how do you defend in that moment? Based on your preparation, your training, your mindset, your experience, like all of these things go into you and your unique decision on when and how to defend. But you should know from the legal point of view that all self-defense is potentially unlawful. All of it. Every single act of violence or threat of violence is potentially unlawful. You should only do it when you need to protect the things that are worth going to jail for and worth dying for. If you do it for any other reason, you are likely taking on more risk than what the benefit justifies. So the thing that I've taken away from all these attorneys and my experience in the legal system myself, and the attorneys that I speak to, and the ones that come and talk in our seminars, and the ones that are online, and the books that I've read, is that you could potentially go to jail anytime you defend somebody, yourself or anybody else. And there's a lot of reasons why that can happen. Most of them are outside of your control. So learn to defend effectively, learn how to defend efficiently, and make the best choice in the moment when that situation presents itself to you. If you can avoid it, you should avoid it if you understand the legal risk. If you can't avoid it, your job is to defend what you care about, defend what you love, defend what's worth going to jail or dying for. In the aftermath, you're going to want a professional to help you through it. And that's why we recommend that you get an attorney. And personally, I recommend that you have a legal plan for how you're going to do that. But what's most important is that you make that phone call and actually get an attorney to come represent you. And that is what all attorneys would agree. All attorneys, and I think they're right about that. That you should have good legal counsel immediately or as close to immediately after your self-defense encounter that you possibly can. So the conclusion here is don't take legal advice as self-defense advice. Take legal advice as understanding risk and preparing for that risk properly in the aftermath. Self-defense advice should be done in the context of what is necessary to defend the people and the people that you care about successfully in a violent encounter, in a dynamic, critical incident. So it's one of the things we say in our classes is we don't teach to the law. I don't care if you understand the law or not. I hope that you understand the risk. But understanding each step of the self-defense matrix, in Branca's book, he calls it the 5 elements of self-defense. Understanding all of that isn't really going to help you in a self-defense encounter. What is going to help you is understanding violence, understanding space and time, understanding risk, and understanding violence in general. But it's chaotic. It's very chaotic, and it's not something that we can legally plan around in the moment. We can legally plan for afterwards. Can't legally plan for in the moment. So that's the best I can do this afternoon explaining this topic. I hope it was useful to you. I encourage you guys to leave comments to argue or clarify. It's important when we're talking about high stakes information that it's open to criticism, and I encourage you to critique the information that I present in these videos. I don't care about subscriptions. I don't care about likes. I don't care about notification bells. I care about conversations to further knowledge in this space. So, thanks for watching. Gunsforeveryone.com. Check us out. Talk to you later.